Hi everyone, my name is Stuart Coulthard. I'm a director at Rubiix Business Accountants, and today I'm joined by Martin Galea, the director of Tickbox Conveyancing. These videos that Rubiix is putting together is designed to provide practical tips to business owners over and above the awesome tax advice that we provide to our clients. This video is going to be all about the tips and tricks around property transfers, as well as the role of a conveyancer. That's why we've got the awesome Martin Galea with us. Welcome, Martin.
Yeah, hi Stuart, how are you going?
Great. So I guess Rubiix answers a lot of questions around property, often when it's buying their home or an investment property or commercial property. Certainly a hot topic at the moment. So again, really topical about bringing you in for this video. So Martin, what is the importance of a conveyancer?
Look, generally speaking, I'd say that our role, obviously we put on a number of hats, whether it be acting for a vendor or a purchaser, or in the case of the subject matter of a transfer, often the parties involved in that transfer, is to properly advise and undertake the transfer of real property from one person to another or one entity to another entity. I'd go further to say to interpret and draft required special conditions in circumstances where there's a transaction occurring between third parties, if you like, or unrelated parties. Have a good understanding of various legislation, such as the Sale of Land Act, the Duties Act, the Building Act, and the Property Law Act, for example, to assist purchasers carry out their due diligence. And ensure that vendor clients comply with their disclosure obligations under Section 32 of the Sale of Land Act to basically complete what's otherwise referred to in the market as a Section 32 statement or a vendor statement.
So really critical in a conveyancer is really critical in a property transfer because you won't be able to do it without it. So get the right advice.
Yeah.
You must see a number of contracts. You've probably seen a bazillion number of contracts. What are the common mistakes that you see with signing a property transfer or a property contract?
Yeah. Look, I would say quite simply the biggest mistake are clients signing contracts without getting advice first.
Yep.
Ideally they should be using our services to review a contract before they sign, particularly in a purchaser scenario, so that we're able to tell them what they're getting themselves into rather than telling them what they've got themselves into. And sometimes there are scenarios where there's no turning back, even though we might be telling them something they don't want to hear. So that would be one of the main mistakes, if you want to call it that. I think understanding how cooling off works, and there are a number of exceptions to the rule to be able to cool off. Most people would sign a contract thinking, oh, they've just got a 3-day cooling off period, they'll change their mind, but it's not that simple. Not signing the contract subject to finance is a big one. People signing a contract believing that their funding will all be fine, and then they discover that when they go to the bank, there's an issue. It might not necessarily be a servicing issue, but might be an issue with regard to the security being offered, that being the property that they've purchased. Understanding terms contracts, which don't happen too often, but for a vendor in particular, it can be scenarios where a vendor accepts certain terms from a purchaser that actually turns a contract into a terms contract, and they can be diabolical if they're not done correctly. You probably, from your end as an accountant, you'll deal with the issue of GST in property.
Yep. So
a conveyance is really important in helping the whole process and communicating with you as an accountant, Stuart, that how's GST being treated? If we're acting for a vendor client of yours or a purchaser client of yours, just as equally, we need to understand the ramifications of how GST is being treated. Is the sale that's being made actually a taxable supply in the vendor's hands? And if it is, then how is it being treated? Is it full 10%? Is there a margin scheme able to be applied? Is it a going concern? And these are all things that need to be dealt with very carefully because, as you're aware, if the deal gets audited in the future and the matter's deemed as a taxable supply and it's not treated properly, then that could be diabolical for a vendor having to try and chase a purchaser for reimbursement, perhaps. Purchaser buys, when the purchaser buys a property, they buy it as is in normal circumstances. So come settlement time, if there's things that, when I say things such as, goods or chattels or fixtures and fittings that aren't quite looking like they were at the time of the sale, there's a lack of appreciation of what the vendor's obligations are in those circumstances, and they're quite limiting in regards to what the purchaser's rights are. Most instances, the purchaser will need to settle and potentially reserve rights to look to sue after settlement. So again, getting back to getting pre-purchase advice, we can certainly try and put conditions in contracts that protects a purchaser, for example. And equally, when we're acting for a vendor, looking to resist such conditions so that our vendor isn't over-obliged. For example, property sold as is on the basis that the vendor must deliver the property in the same state, fair wear and tear provided. If a hot water service is on the way out, and that's just the nature of it, then a vendor shouldn't have to replace it necessarily with a brand new one or even repair it. So it depends which hat we're wearing. And I'd say not obtaining a building and or pest inspection report is another common mistake, particularly when a client buys a property, wants to renovate, thinking they've got a certain budget, and then added to the budget ends up being, rotten timber, for example, because of pest damage or, water damage issues and the like. So they're quite, I would to summarise mistakes in that way. There's probably a lot more I could highlight, but we'll be here forever.
So I guess you are signing a legal contract. So you got to know what you're signing. So having someone to run through those sort of things and knowing the ins and outs is really important. So let's say I own a house, it's in my name, and I want to transfer that to my spouse. Can I do that easily? Let's say it's a couple of years down the track.
Yeah, you certainly can. Whether it be your residential home or whether it be a commercial property, there's no stopping anyone from transferring the property to a spouse, a domestic partner, a family member, another entity that's related. The issue always comes back to whether the transfer is dutiable. So every time a property is transferred, then stamp duty needs to be considered, and you need to go through an assessment process with the State Revenue Office. Even when you fit the bill completely that you're entitled to an exemption. So, for example, if you're if you're transferring a residential home from husband to wife or wife to husband or domestic partners, that the conditions to obtain an exemption will be things like that no money's changing hands, that the dwelling's actually the principal place of residence, and that it will remain the principal place of residence for at least 12 months for the person receiving the transfer.
Yep.
Anything outside of that residential space, if you like, is most likely going to be dutiable unless you're able to show that the beneficial ownership isn't changing and that there's no third party benefiting as a consequence of the transfer, and that no funds are changing hands. And that the State Revenue Office has a manual that contains all the evidentiary requirements needed to assist it to make a proper assessment of whether duty is payable.
Cool. We get asked that question a fair amount. Another question that we sort of have a conversation about with our clients is often around risk. So transferring risk from them personally into another entity. So again, if I own a house or a home and I decide I'm too risky, can I transfer that to a trust or another entity?
Yeah. Look, most instances I would say, well, the answer is yes, you can do it.
Yep.
And the burning question will be around stamp duty.
Again,
and it will come around the issues of the nature of, for example, if you're transferring it from a trust, as you know, trusts can be quite complicated. whether they be a family discretionary trust or a fixed unit trust, for example. And the super funds, of course, you bring those into the picture. You're always needing to deal with, again, looking at the types of exemptions that may be available in those circumstances, and whether or not the evidentiary requirements that are required may lead themselves to having a duty-free transfer.
Yep.
We always take a conservative view that stamp duty needs to be assessed. There's no guarantee that it will be exempt. But at the end of the day, if property being held by a certain party is risky from an asset protection perspective, then worst case scenario, stamp duty will need to be paid if you absolutely need to get that property out of that person's name.
Yeah. So I guess I go down the path of you need to get the right advice before you do anything like this. And that's why we have experts like you, Martin. Another thing that we see a lot, and probably in the last couple of years, is dealing with the ATO withholding certificate. When should you organise that ATO withholding certificate?
I think in an ideal world, once a vendor decides they're selling and the vendor instructs a conveyancing practitioner to handle the conveyancing work for them, I see no reason why a vendor shouldn't apply for the ATO certificate there and then.
Yep.
It's a certificate that is valid for 12 months, first and foremost. So getting it early means it's going to you're going to get the benefit of it for 12 months. It takes usually about 28 days to get. And of course, if you've got a 30-day settlement and you're scrambling to get it, 2, 3, 4 days after you've sold the property, it's leaving you with only 26 days to get your ATO certificate. So we've seen a bit of anxiety around that.
Yes, we certainly have.
Yes, so I know you've experienced that recently with one of your clients. Sought some advice from me in regards to how to handle it. I was able to put you in the right direction. Yeah,
certainly, and it certainly helped. Another thing that we see often as well is around transfer of property. Other banks, because the banks are often a party to these transfers, sure. Are they happy often with property being transferred from, let's say, husband and wife?
Yeah, so I suppose the first thing we've got to look at is, the bank, that's for the purpose of, getting into sort of a little bit more technical, is that the bank is often referred to as the mortgagee. And as a mortgagee, the mortgagee is required to consent to a transfer taking place whilst they're on title. So we will advise our clients immediately once we're instructed that they want to transfer the property, that they need to make sure that their bank is aware of the pending transfer and explore whether the bank has any reason to deny the transfer without potentially reviewing the debt arrangement and or looking to refinance the current mortgage. And that, of course, mostly occurs when there's a breakdown in a relationship and one party's transferring from the other, and there's a mortgage that involves both of them. The one coming off the title obviously doesn't want to be party to the mortgage anymore.
Yeah.
But let's say a typical domestic partner arrangement, where let's say they're moving it because of asset protection reasons, for example. For the mortgagee, the security is not changing. And their debt arrangement and their financing arrangement usually means that both parties are still responsible for the debt anyway. And if they fail, they being the domestic partners, fail to make their payments and the mortgagee steps in as a mortgagee in possession, for example, well, they're just going to rely on the sale of the property and hopefully recover their debt. And if there's a shortfall, they'll chase both parties.
Yeah.
So in essence, whilst the bank need to know about the transfer and consent to it, and by the way, their consent is demonstrated simply by making the title available at the titles office to allow the transfer to go through. The bank certainly need to consent to it and agree, but mostly will agree. I can't recall the last time a simple transfer between domestic partners, whether it be residential or commercial, was knocked back.
Okay. So again, thank you so much for coming along and participating in this video. It's property and property purchases, property sales is really a hot topic at the moment. I'm sure you agree with that.
Yeah.
So getting the right advice, knowing what you're actually signing and the clauses in there are really important. So talking to an expert like Martin and the guys at Tickbox Conveyancing is really, really important. If you've got any questions for Martin, there will be a next slide after this video with Martin's and his team's contact details if you've got any questions. But thank you so much for coming along and listening in. And thank you, Martin.
Pleasure. Thanks, Stuart, and all the best.
No worries.